we're going to get started in just about a minute. What I'm going to do right now is I want to kick it over to Courtney Buchan over from GRS Community Management. Courtney will mention a little bit about herself and her company, and then she'll kick it over to our other participants for today. Courtney, take it away.
Thank you so much, Jeff. Thank you. My name is Courtney Buchan. I am the current corporate trainer for GRS Community Management. I am also a licensed CAM and a board member myself. A little bit about GRS. GRS is a mid-sized management company based out of Lake Worth, Florida. We service over 240 communities all across the state, East Coast, West Coast, North, South, you name it, we'll manage it. Condos, HOAs, co-ops, we do it all. If you want more information about our management services, you can visit our website at grsmgt.com. You can also check out our social medias on Facebook, Instagram, X, LinkedIn, of course, or you can email me. I know Jeff at the end will most likely put up my email, but my email is cbuchan@grsmgt.com. So I'm very excited about today's presentation. Like I mentioned, I'm a board member and my community happens to have a construction project that we're trying to get funding for. So I know this is going to be great information for those board members and managers that have these projects. There's a lot more that goes into it than most people think. As a baby manager, I thought like, oh, we just go get a loan from a bank, and it's not that easy. So we have Mary and Karen from Bank of America. They'll be going over more of the financing side. And then we have Kerstin Henze from K. Bender Rembom. I've done a lot of different webinars with her. She is out of the Tampa area. She is the managing firm member for that Tampa office. Great to have you, Kerstin. So with that being said, I'm going to turn it over to Mary to go over what she does at Bank of America. And before I do that, I will be answering some of the Q&A questions. I always like to put out a disclaimer. I am not an attorney. I am not a financial advisor. I will do the best while the two ladies are giving their presentations to answer all of your questions. Some of the harder ones I'll leave towards the end so Mary and Kerstin can address. So just keep that in mind and definitely take notes. And without further ado, let's turn it over to Mary.
Thank you, Courtney. I appreciate the background and information, and I think it's going to be an exciting webinar today. So my name's Mary Cohn. I'm a Senior Vice President with Bank of America in the business banking sector. So we serve clients basically from 1 million up to 50 million in the South Florida market. So anywhere from Naples up to Tampa and across. And Karen Simpson, who's also with us today, she sits in our St. Pete office. So we, throughout South Florida, we obviously see a lot of condos, HOAs, and now especially with some of the change in laws that we're seeing a lot more questions arise. As Courtney said, like, we think we're going to need a loan. How do we do this? So I'm hopefully going to give you kind of a high overview of what information you're going to need. And if you have questions sometimes like, well, why do you need that type of information? Well, it really just helps us understand kind of how you operate, because I will tell you, looking at bylaws and amendments and articles of incorporation, no two are the same. Everyone is unique. And so trying to come up with what some people would say is a cookie cutter approach doesn't work. So we really want to specialize our solution to your uniqueness of your HOA, your condo, your board. So that's really what I'm hoping, that will help you understand. So Jeff, did you want to put up my slide that kind of talks about, or not?
Screen sharing is enabled for you, but I'm happy to do it if you're not equipped to do that. Just give me a second here. Hang on.
Yep, no worries.
All right. And folks, there were a couple of questions in there that I saw. But while I'm pulling up the slides, I do want to introduce as well Kerstin Henze from our Tampa office. And in addition to that, there were a couple of questions on here about a discrepancy about time. And for those of you who don't know, I sit on an advisory board for Zoom, and I've reported a technical glitch The advertisement did say 12 noon. What happens is anytime Zoom has a product update on the back end, it reverts back to defaults of a template. So the default of the template had this course listed at 11:30. So some of you saw 11:30, some of you saw 12 noon. So that's been reported. Again, I sit on their advisory board for product updates. I'm one of the lucky ones, and they've been made aware of that. So we apologize for that inconvenience for those of you affected by that. Kerstin, while I'm pulling up the slides, please mention a little bit about yourself and K. Bender-Rembaum.
Yes, hello everyone. I'm Kerstin Henze. I'm one of the firm members and managing attorney of the West Coast office for the firm, which is located here in Tampa. For those of you that are not familiar with the firm, we are a full service community association law firm. So that is 100% of what we do. We don't practice any other area of the law other than community association. So we represent condominiums, HOAs, and co-ops from their day-to-day operations of the board of directors to construction litigation to collections and foreclosures. We have 22 attorneys throughout the state of Florida. We have also other locations. Our main office is in Pompano Beach, Florida, South Florida, and we also have offices in Palm Beach Gardens and Orlando as well.
Wonderful.
And I'm going to be talking specifically about the different funding options, one of them being financing and borrowing, which Mary will be discussing in more detail.
Absolutely. Thank you so much. And now we're going to kick it back over to Mary. Mary, my friend, here is the screen, and you are on.
Wonderful. If you can go to the next page, then we
got
will. Good to go. Thank you, Jeff.
You got it.
So anytime we meet with a client, we always ask kind of for like our wish list of financial information. So the first thing is always, we'd like to see 3 years worth of financials. Typically, we want to see them that they were either audited or reviewed statements. That just kind of gives us more comfort with the quality of the statements. We can always start with tax returns, but again, they kind of have different rules and reporting requirements. We want to understand your budget and how you're actually comparing your budget, to the actual year-to-date results. So if your budget, your fiscal year ends 12/31, and we're now basically through, September, we would hope that at least through June 30th, we have something that we can kind of compare the numbers to. And then also, if you're in the process of budgeting for the next coming year, we'd love to see that as well, especially with those capital budgets, which is what you're going to be looking to finance. The other part we want to understand is kind of who are the residents. Do you have a history of any residents typically with delinquent problems? How do you handle that? Again, just so that we can kind of look how do you get paid? Do you get paid quarterly? Do you get paid annually? We kind of want to understand that. As I mentioned before, the bylaws, declarations, and amendments, that's key for us to understand the individuality of how you operate and how you're set up. So those are definitely keys. Now, once we start talking about the project, we want to understand what's the purpose of the project. Obviously, you have some type of capital improvements that you need to do, and you're trying to come up with how are you going to finance that. So that's kind of where we want to understand the capital reserves. We want to understand, is the project really just to fix deferred maintenance, or are you actually doing something that's really going to be proactive? I know there's several condos down here that are still recovering from the hurricane a few years ago. So they're still in the, I'd say, reactive phase where they haven't really started looking out forward, like what else do we need to do? The other part we want to understand is, have you really started dealing with contractors? Do you have a contract? Is it a fixed price contract? Are you going to require any type of payment and performance bonds. Again, those all are kind of on the scope of the project. We don't see those for smaller projects, I'd say, you know, 2 million or less. But if you're looking for a larger project, you definitely want to make sure that that contract kind of has some safety features with it. The other part is, like I said, the project itself. Help us understand what the project's going to do. What's your time frame for the project? The earlier you bring us in, the better. There's nothing worse than someone saying, we told the residents we're going to start a project November 1st, and we're sitting here October 1st, and that's just not a doable time frame. So as you're contemplating it, you definitely want, I would say, at least 4 to 6 months ahead of time, just because there's a lot of moving parts, and we want to make sure we're part of that process. The other part is, have the residents actually voted to do the project? And do you have the support of the residents, or are there some that say we don't need to do a project so large? What should we be doing? We want to see that the residents support the project. So we're most likely looking for some type of vote. We'd like to see at least probably 2/3 supporting it. Ideally, we'd like it probably in the 80% range, because historically when we see the lower approval rates, we're definitely seeing people or residents, I'd say, kind of causing problems within the HOA. Let's just put it that way. They're not happy residents, and they're the more vocal residents. So if you can get more people on board, that always makes it easier. The other part when we look, especially at condos, is how many are truly owner-occupied, or are there a large percentage that are timeshares or rentals? How does that work? We typically don't like to see a majority, obviously, being timeshares. We really want to see the owner-occupied type of project, just because there's more inherent risk with that. And then the next part is, have you figured out your assessments? How much is the project? Have you figured out the useful life of that project and tried to match those assessments with that useful life? So when we look at renovation loans, we want to say, okay, you're putting on a new roof that's going to have a useful life of 10 to 15 years, and you're putting in a new deck that might have a useful life of 10 years. Well, we're not going to finance something 20, 25 years. It's going to have to match that useful life. And typically we want to see it before the useful life, because most HOAs and condos don't want to continue that repetition of every time we need to borrow when there's a small project. And we know that there's going to be continued projects going in the future, especially, you know, in the Florida market, where you have unexpected events like, you know, the hurricanes that we've had that cause sometimes damage that you might have to react to. So again, not having a large amount of debt out there gives you more flexibility kind of for those contingencies. The other part, when you look at the project, who's going to manage the project? Are you hiring a construction manager? That they should be separate from the contractor? Who's going to monitor any cost overruns? What type of contingencies do you have in place? If you do have cost overruns, are you going to be paying for those out of pocket? Are you going to come back and want, you know, a higher loan? Those are all things that we would kind of talk through, like I said, in that 4 to 6 month process, so that we can kind of understand, like, let's just say you have a $10 million project. We would probably want to see a healthy contingency. And then once the loan gets funded, if you don't need that full amount, we can obviously amend it at that point in time, you know, for the amount that was funded. But if you go over, then we really have to understand, you know, what are the repayment sources? Banks are cash flow lenders. We look at the cash flow. So if we're looking for the quality of your assessments from your residents. So that's really what we're going to focus on. And we want to make sure that the assessments, what they historically have been and what you're proposing is something that the residents can afford. You don't want to be increasing your assessments or doubling your assessments because that's just not gonna help. You're gonna have a lot of unhappy residents, and you know, and you're just gonna have a lot of issues, I should say, with that type of plan. So those are the kind of items that we want to talk through and understand. And I think that's pretty much all I have on my side. So I'm going to turn it over to Kerstin.
I'm sorry, Kerstin. Mary, I just wanted to clarify something. You had said that you would like to see votes from the community 75% in favor of a project, but not every community is going to need a vote for certain projects. Sometimes it's repair that's needed, that's very costly, that just needs to be done. So I don't want everybody to think that every time you have to do a project, there needs to be a community vote. If it's a material alteration change over a certain amount and it's labeled in your docs, that's when you would need that community vote. But like something like your community needs roofing, right? You have buildings that needs roofing. That wouldn't necessarily require a vote to get new roofing. If the roofing's past its lifespan, it's something that you most likely reserve for in your reserve budget, and then you would do that. And then also, you said something at the very end that I just wanted to comment on before Kerstin started her part of the presentation, because I thought it was important, and I'm blanking on it, but it was something about, what was the last thing? I was so focused on the whole voting thing. The contingency money. So a lot of people don't understand that when you go get a loan, you have to put money down for that loan. It's not just something that you can just go to any bank and say, hey, I want a loan for $50,000 or $150,000. You have to put something down to get that loan. So make sure that you have that money set aside. And then that reminded me of what I really wanted to bring up was about funding this through your assessments for like upping your budget. So I've had communities, because I figured this is a good example, I've had communities do it that way, where they had a project and instead of doing a special assessment, which everybody's always afraid of special assessments, I get that, but special assessments aren't forever, hopefully. Special assessments are usually for a certain time period. So if you inflate your budget to cover the cost of a project, potential buyers could look at that as a negative, like, oh, wow, those fees are really high. We don't want to buy in there. So that's what I wanted to comment on. Sorry, because that happened. I had a board and I advised them, I was like, I don't really think we should do it this way. We should do a special assessment for this and leave the budget the way it is. They didn't want to do it that way. They put it in the budget. So then the budget went from, $900 a month or a quarter to like, I don't know, I think it doubled. It was like almost $2,000 a quarter. And that looked really bad to potential buyers. So I'm glad that you mentioned that, Mary. So sorry. So with that being said, that's all the comments I had. So Kerstin, you could go ahead. I just wanted to interject because those were two important points I wanted to make.
Thanks, Courtney.
Absolutely.
And I'll touch on that in a minute. Let me just pull up my slides.
Yeah, Kerstin's going to share the screen. And while Kerstin's doing that, I just want to mention, because I failed to do this earlier, towards the end of the webinar, we're going to place a link into the chat area. You're going to click on that link. That'll take you to the evaluation, and that'll allow you to download all of our slides today. That'll get you a certificate. So if you don't see the chat area, that is not the Q&A, two different things. If you don't see the chat area on your interface now, it's on the lower right-hand corner. Hit the chat button at the bottom and it'll appear. It may say chat is disabled for you. It is. You can't chat our way, but we can send stuff your way. So that's where you'll be looking a little bit later for the evaluation link. And I see the slides are up. Kerstin, it is all you, my friend.
Thanks, Jeff. All right. If it only wants to cooperate.
Technology is wonderful when it works.
It is not moving.
And if it doesn't, I could open them up as well. Just let me know if you still have a slight struggle with it.
All right, let's try this again.
Folks, I would hum the theme of Jeopardy if it weren't a copyright issue. So
All right, here we go.
there we go.
So let's kind of take a step back. Let's kind of start with some pretty basic stuff. Some large expenditures, right, that you might be having to deal with at the moment, right? So certainly emergency mitigation, right? We just had a hurricane and certain parts of Florida were affected. So that could be your large expenditure that you're looking to fund now. You could be having to deal with certain code compliances, or for example, if you are presently located in South Florida, you might be dealing with recertification requirements. So there's at least 2 counties in the state of Florida that I'm aware, Broward and Miami-Dade, that could be that require recertification of your buildings, of your condominiums. So typically that is a costly undertaking. Concrete restoration, certainly a lot of condominium buildings, especially the older ones, have to deal with this. Fire life safety code upgrades, and that includes your ELSS. Those are certainly not cheap. And then, of course, there's the replacement or substantial upgrades to your building components. For example, elevator modernization. That's an expenditure that doesn't really get a lot of attention, but a elevator modernization project could easily cost a few $100,000. And then depending on how many elevators you have in your building, I mean, you could be looking at, $500,000 plus dollars to modernize your elevators. You could have seawalls. Seawall repairs are not cheap. We have a client that's presently looking up to $1 million for a seawall repair. So, all right. And then what are your basic sources of funds? Okay, so you have your annual budget, and Courtney just mentioned that there are some boards that might include the cost of the project as part of your annual budget. It might make sense if that is a small project. So depending on the scope and then the timeline of the project, you might just assess the cost of the project as part of your annual budget, right? And owners will pay assessments through their regular, maintenance dues. That is unlikely, however, for bigger projects, right? The more likely scenario is that you might have to adopt a special assessment, and we'll talk about that in a moment. You also have reserves as a potential source of funding, and then there's borrowing and financing that Mary just discussed. So let's go to reserves first. So what is really even a reserve study, right? Because I hope at this point, none of this is new, especially when with regards to the structural integrity reserve study. But a reserve study is essentially a study of the reserve funds that you will need in order to undertake repairs of certain building components, right? So with the CEUs, associations that have existed before July 1st of 2022, which are owner controlled, you know that you have to have your CEUs completed by December 31st of 2024 for each building that is 3 stories or higher. And then every 10 years thereafter, right? So hopefully at this point, you've either had your CEUs completed, right? Or you are under contract with an engineer or an architect licensed in the state of Florida, or a reserve specialist to do the visual inspection and then complete your reserve study, okay? December 31st, that is a deadline. The legislature has not changed that deadline. Now, if you are in a condominium association that manages or operates buildings that are under the 3 stories, while you don't have to do CEUs, your reserve obligations have not gone away. Okay, so you still have an obligation to fund non-CEUs reserves. Now, if you haven't done a reserve study in a while, now is a good time to do that, right? Because what the reserve study specialist or engineer is going to do is basically visually inspect your building components, right? And then calculate how much reserve funding you will need for each building component to make sure that when that component is due for repair replacement, you have sufficient funds in place, right? So the statute outlines the building components for which you have to reserve under CEUs. And then if you don't fall under the CEUs requirements, you still have your basic four components that you have to fund for, right? Your building painting, your roof replacement, your paving, and then any other deferred maintenance expenditure that will cost over $10,000 to repair. Now, calculation of your reserve funding, right? This is what your engineer or your reserve specialist will be doing. And essentially, they will figure out for you what the useful life of the asset is, the remaining useful life, what is the estimated replacement cost, right? And then they will provide you with a reserve schedule of how much you need to fully fund those reserve items. Now, to be clear, fully funding doesn't mean that you have to come up with all the funds immediately, right? To fund the replacement. It means, let's take your roof replacement. If you have a roof that has a 10-year remaining useful life, and it's going to cost you $100,000 to replace that roof at the end of those 10 years, well, you know you'll need to fully fund $10,000 each year for the next 10 years, right? In order to be fully funded at the end of the 10-year window. That's what fully funding means. Now, pool versus straight line reserve methods. Now, pooling is going to be your most convenient, right? Your most beneficial for funding large projects. Now, you can pool CEUs reserves, right? And you can pool non-CEUs reserves. We just don't recommend that you pool both CEUs and non-CEUs reserves together, right? And that's for those communities that have to do both. Now, whether or not pooling will require a vote of the majority of the voting interests, well, that's something you'll have to discuss with your legal counsel, right? Because depending on, if you've had already reserve funds and you want to start pooling those, that might require membership vote. If you're just starting, for example, your CEUs reserves and you want to pull them right away, that might not necessarily require membership vote. So discuss the specific facts of your situation with your legal counsel and get their legal opinion as to whether or not pooling will require membership approval. But the benefit of pooling is that if you have pooled reserves for a number of components, for example, your roof replacement, your building painting, let's say your elevator modernization, and let's say, roof replacement, you have to get your roof replaced right away, right? You can't wait, another year, but you're short on your roof replacement funds. Well, you can take funds from the other components within the pool in order to fund that shortfall on your roof replacement. Now, eventually those funds will have to be replaced, and that's a discussion you're going to have with your association accountant, but it will give you that flexibility, right, to fund projects. And again, it's only for items that are within the pool. Okay. If skip down here to alternate use of reserve funds, what the legislature has now adopted in the statute is that for budgets adopted on or after December 31st of 2024, for those associations that have to do CEUs, you will no longer be able to use your CEUs reserve funds for alternate purposes. So if you're not pooling your CEUs, if you're doing straight line accounting method for every single CEUs reserve item, then you could only use those CEUs reserves for the particular purpose for which these funds are being designated for. So your roof replacement could only be used to replace your roof. Your building painting can only be used for building painting. Okay, that's for budgets after December 31st. So you can see why pooling will become beneficial. Now, if you're not required to do CEUs, right? Well, you still have the option to use your reserves for alternate purposes, but you do need to get a membership vote. So those condominium associations that don't have to do CEUs, you still have a little bit of flexibility with those non-CEUs reserves for alternate uses. You just have to get a vote of the membership. And the vote that you need to get is now a majority of the voting interest. So it used to be that you would need to get a vote of the majority of the owners who are present at a meeting, which is a majority of quorum. But the legislature has changed that voting requirement. This was a change in the statute last year. So now they've made it a little bit more difficult to get that vote. So it's a majority of the voting interest. So if you have a condominium building with 100 units, you'll need to get a vote of 50% plus 1 to use your non-CEUs reserves for alternate purposes. Now, with regard to waiver and partial funding, if you are required to maintain CEUs reserves, okay, then those associations will no longer be able to waive or partially fund those reserves for any budget that's adopted on or after December 31st of 2024. Okay, so for budgets, if you adopt a budget after December 31st of 2024, okay, those associations have to fully fund those CEUs. End of story. So what that means is that if you're an association that is not yet ready to fully fund your CEUs, provided you've already had that prepared, you still have a very small window, okay, to get those reserve funds waived or partially funded. That does take a vote of the membership. So it is an issue that you're going to have to present to the owners for a vote. But provided owners have voted to either waive or, you know, voted to partially fund those CEUs before December 31st of 2024, and then the board adopts the budget with either partial funding or waived reserves, then you don't have to fully fund reserves for 2025. Okay, so then you would start fully funding those CEUs in 2026 for the 2026 budget year. So that gives you a small window of flexibility in case you have, for example, you know, some major project that you're undertaking right now and you need to shift those funds to the project. Now for HOAs, the real big question here of whether or not you are required to maintain reserves, and I mean statutory reserves, is whether the membership established statutory reserves. Okay, so with HOAs, it requires a vote of the members to establish statutory reserves. And what you'd need to do is you'd need to look at your association records for the last 7 years and longer if you have those records to see if there was ever a vote presented to the owners to establish statutory reserves. What that means is that if owners voted to establish statutory reserves, and that would have required a vote of the majority of the voting interest, then those funds that you classify as reserves would need to be funded and maintained in accordance with the statute, which means you can't waive or partially fund those reserves unless the membership has voted the waiver or the partial funding, and you cannot use those funds for alternate purposes unless the membership has approved that alternate use of funds. If you do not have association records that confirm the membership established statutory reserves, then it is very likely that those funds that you classify as reserves are nothing more than a contingency fund or an emergency fund, which means then you have a little bit more flexibility on how you can use those funds, and you could use them for any bona fide association purpose without necessarily the vote of the membership. Okay, so you'll have to really just kind of dig into your association records to confirm whether or not statutory reserves were established or not for your community. All right, so let's go to special assessments. So special assessments is yet another source of funding, and this could be adopted in conjunction with use of reserve funds to fund your project, or even, you know, if you're borrowing funds, right? Or you can simply, you know, fund your project with just adopted special assessments. So the statute and hopefully your governing documents would give you, the board, the authority to adopt special assessments, right? Now, the statute is both 720 and 718 are very specific as to how to properly adopt a special assessment. And it is so important that you follow the statutory process, because when it comes time to collect a special assessment from an owner who has been delinquent, if you didn't follow the statutory process, then the owner's attorney can certainly challenge your claim of lien and certainly any foreclosure action, right? So if you were to refer a delinquent owner to our office for collection on a special assessment, we will be requesting from you a copy of the notice of the meeting and all the supporting documentation to make sure you did it right before we start collections. And if you didn't adopt the special assessment properly, we will tell you or advise you to do it properly, okay? So in terms of the content of the notice, well, the statute says that the notice of the board meeting at which you can adopt the special assessment has to provide the purpose, describe the purpose of the special assessment, indicate that you're adopting a special assessment, and certainly include an estimated cost. And then importantly, the notice of the meeting at which you're going to adopt the special assessment has to be either mailed or delivered to the owners, or electronically transmitted to those owners who have consented to receiving notices electronically at least 14 days prior to the board meeting. And then you also have the obligation to post that notice in a conspicuous place, either in condominium or HOA property, at least 14 continuous days prior to your meeting. Certainly, if you have in your bylaws a longer notice requirement, then go with that, but at least a 14-day notice. And again, just as a reminder, to email notice of this meeting, again, you will be emailing it officially to those owners who have consented to receiving notices electronically. So if you don't have a written consent from an owner saying, I authorize or I consent to receiving association notices by email, then electronic transmission does not serve as the formal notification of that meeting. Then you'll have to either mail it or hand deliver it, and then you can, as a courtesy, email it to the owner. Now, typically, you know, it's a board decision, right? Whether or not you want to adopt a special assessment to fund a project. And your authority is going to be derived from the statute and then your governing document, right? And then typically the board is the one that adopts the special assessment. There could be, however, some limitations in your governing documents, and every community is different, right? So check your governing documents, and for condominiums, this will likely be in your declaration. For HOAs, this would likely be in the bylaws, but you could have a provision or a clause in your documents that basically say that if the board is going to fund a project with a special assessment, then membership approval is required, right? And then depending on the language, it could be that membership approval is required regardless of the expense of the project. As long as you're funding it with a special assessment, you need membership approval. Or you could have a clause that says only if you exceed a certain dollar threshold, then you'll need to get membership approval. So check your governing documents first. That said, okay, if this is, if you're adopting a special assessment in conjunction with a capital improvement that is a necessary maintenance obligation of the association, so roof replacement. You have to replace the roof of the condominium, right? That's a necessary maintenance obligation of the association. Then there has been case law developed in Florida that says that if you're adopting a special assessment in connection with a necessary maintenance obligation of the association, then the board does not have to get membership approval for that special assessment. So you can adopt your special assessment without the need for an owner vote. Now that is very different, and Courtney had mentioned that is very different from a material alteration. So going back to the roof replacement example, you have to replace the roof. There's no question about it, right? That's a necessary maintenance. You need to adopt a special assessment to fund that. Okay. You might not need membership approval to adopt the special assessment to fund the replacement. But let's say in the process of replacing the roof, you want to change the shingle. Okay, that is what is known as a material alteration. Okay, and the statute, the condominium statute, says that material alterations do require membership approval. And it's typically 75% of the membership unless your governing documents provide otherwise. So if you're in that situation, speak with your legal counsel to see whether this material alteration requires membership approval.
Kirsten, may I ask a question about
Yeah.
material alterations that comes up a lot? It's very confusing for many people. Is that okay? Is that okay? Okay.
Yeah.
So let's say this is the example that comes up quite a bit. You have a tennis court, all right, but they also want to have a pickleball court on property, and they just go ahead and paint lines on the tennis court so that you can play either or on there. So you're not changing the function. You could still play tennis on it, but it could also be used for pickleball because you have different colored lines for pickleball. Is something like that considered material alteration in your opinion?
Very likely. Yes.
Okay.
Because the division and case law have defined what a material alteration is, and it basically is, any exterior change. So even though it seems like it's a minutia, the fact that you're just putting on some extra lines, that most likely is a material alteration. Now,
okay,
whether that requires a membership vote, that's a different analysis. Yeah.
Okay. Just want to head it off. I know we'll have 27,000 questions about that in there eventually. So I just wanted to head it off at the pass.
Sorry, real quick, I have to interject, Jeff, it's so funny you brought up that example because that literally happened in a community I managed where we had a basketball court. We were getting it repainted outside, and the painter said, hey, we can throw in pickleball lines for free if you want to add them. Huh. And so we did. I did ask our attorney. He's like, I don't see a problem with it. You're not really changing it. You're just adding these lines. You're not changing it from a basketball court to a pickleball court. So I'm fine with it. You're just giving it another option how it could be used. And there was an uproar about those pickleball lines, and people brought that up and got all upset about it. So it's funny you use that example.
Yeah, material alteration is never an easy topic.
Yeah, because it can be a little confusing.
It can be, and that's why I always encourage clients, speak with your legal counsel, because the consequence could be substantial. Right?
Yes.
Especially, with a condominium, you can get a division complaint, and then if a violation is found, you're looking at monetary penalties.
Yes, and in my case, that's what we did is we got our counsel to give us like a statement, and we sent that statement out to the membership saying, hey, this was not defined as a material alteration. This was just an add-on. We weren't changing the use of this area. This was just an extra feature that we thought would be nice to be provided. And it didn't cost us any additional funding. It was literally included in just repainting the basketball court. So yes, definitely go with your counsel, your attorney, if you're unsure. It better safe than sorry every time.
And it really will depend on what your governing documents say. So I want to put that out there. Because the statute does say it's 75% approval requirement unless your governing documents provide otherwise. So that is why your legal counsel has to review your documents, and everyone's documents are different. But getting back to special assessment. So when you're ready to adopt the special assessment at the board meeting, this is where we encourage you to get your legal counsel involved. Certainly, in the preparation of the notice, or at least have your legal counsel review your notice before you mail it out to the owners. But also, and probably more importantly, in the preparation of the motion that you're going to be adopting at the meeting, right? So your motion is going to identify basically the terms of the special assessment, and the board is the one that gets to determine what those terms are. When is the special assessment have to be paid? Are you giving owners the option to pay in a certain number of installments, or does this have to be a lump sum amount? You'll certainly want your motion to reflect that each owner is going to be paying the special assessment in proportion or in accordance with the percentage that they own in the common elements. So that's something that's going to be set forth in your declaration. And then you'll also want your motion to indicate what will happen to the special assessment if the unit is sold before the special assessment is paid off, right? So you want to have that discussion with your legal counsel. One option could be that you as a board might want to require the full special assessment to be paid off at the time of closing. Or you might want the buyer to assume the remaining payment obligation. That is a board decision, right? But you want to make sure that your motion reflects the decision of the board. So it will require you to prepare it in advance of the meeting. All right, and then borrowing financing as your last option. I mean, certainly not your last option, but it's the last option that's on these slides. Again, it is a board decision, completely within the discretion of the board if they want the association to borrow funds, whether it's to fund the full project or a portion of the project to avoid the owners having to pay a big special assessment. The authority for the association to incur debt should be in your governing documents. Typically, that would be in your articles of incorporation or in your bylaws. But if your documents are silent, don't be frantic. The authority is also in Chapter 617 of the Florida statute. Chapter 617 is the statute that governs not-for-profit corporations. And as you may be aware, the association is a not-for-profit corporation. So 617 gives you the authority to borrow funds. Now, it is a misconception that borrowing of funds, is only a board vote. Okay, it may or may not be true for your particular community. And you would need to look at your articles of incorporation and your bylaws to determine whether membership approval is required to borrow funds. Okay, now, unlike with the special assessment and the necessary maintenance exception, right, to the membership approval requirement for borrowing funds, if your documents require owner approval for the association to borrow funds, there is no exception under the law to this requirement that, just because you need to borrow these funds in connection with a necessary maintenance obligation, there is no such exception for borrowing funds. So if your documents require membership approval, you will need to get membership approval. Okay, and one of the things we'll talk about in the next slide is one of the conditions to closing on the loan is that you will likely need a letter from your legal counsel. And among other things, your legal counsel has to attest that if membership approval is required for you to borrow funds, that you have obtained that approval. Okay, so this is why we encourage you to get your legal counsel involved early on in the borrowing process, to, among other things, confirm whether membership approval is necessary. Now, your meeting notice, again, have your legal counsel confirm what are the notice requirements for the meeting at which you're going to approve the borrowing or financing of the project. And certainly if you're going to be adopting a special assessment in conjunction with the borrowing of funds, you will need that notice to go out at least 14 days prior to your meeting. Your motion at that meeting at which you're going to be approving funding should specify the loan amount, the name of the lender, your interest rate, repayment terms, okay? Detail the nature of your renovation project. You'll want to indicate what is the total amount of the special assessment that is being adopted to pay back the funds borrowed, and what is the per unit amount. And again, you'll want the motion to reflect what's going to happen if that special assessment is not paid off completely before the unit is sold. So you'll want to have those discussions with counsel. And then lastly, just want to bring to your attention just some of the loan or closing documents that you might be looking at if you're looking to borrow. Now, your commitment letter is probably one of the first documents that you're going to be looking at, right? And again, this is where you want to make sure your legal counsel is involved, because a commitment letter is basically a contract. It's an agreement between the lender and you, the association, and it's going to contain the terms of the loan, right? So the commitment letter is what basically initiates the borrowing process, and all your loan documents are going to be basically drafted from this commitment letter. So have your legal counsel review the commitment letter before you sign it. Once you sign it, it's a contract, right? You're going to also have a promissory note. So you want to make sure that the terms are accurate.
Did we have a freeze up? Looks like we had a freeze up.
Well, the bank basically steps in the shoes of the association and then can lien and foreclose, right?
There we go.
But you want to make sure, excuse me, that your collateral is narrowly tailored. So the definition of what your collateral is in these loan documents, it really should be or consist of your general assessments, except those that are designated for reserves, and really any special assessments that have been approved to fund the funds borrowed. Nothing else really should be your collateral. Now, some of your closing documents that you will have, you'll have minutes of the meeting at which you approve the loan, the special assessment, the construction project. You'll have your board resolutions, your counsel's legal opinion. Again, this is the opinion that your legal counsel has to do, confirming that you do have the authority to borrow, that if membership approval was required, that you have obtained that approval. And there's really no reason for the attorney to believe that the association would default. There's going to be insurance documents that will need to be provided, association governing documents, and certainly, all contracts with contractors, engineers, etc., in connection with your project. And then again, just be aware, as Courtney had mentioned, there are going to be some closing costs, right? It's not like you go to the bank and, take out a loan at zero cost. There are some costs involved. For example, association counsel fees. You could also be paying some of the lender's fees. There's going to be recording costs, documentary stamps, and origination fees involved, okay? And that's it. That's all I got. If any of you ladies want to add any additional comments to what I've just talked about, or if you want to go straight to Q&A.
Good stuff. What I will ask, if I may interject, is take a look at the Q&A, and I'll briefly go over the evaluation process real quick. I did place the link into the chat. I'll do so again before everybody leaves later. I'll explain this one more time. So while you're looking over the Q&A, click on that link in the chat, folks. It'll take you to this page here. This is where you want to choose yes or no if you'd like contact from any of our experts today. And then after you submit the evaluation, your screen showing a successful submission, this confirmation screen, you can download your certificate here if you'd like to have one. You print it, then you can type and write your name and CAM license number in if you choose to do so, if you'd like one. And then you can click here to download the KBR slides. You can click here to download the Bank of America slides. And then we have a wonderful 2024 legislative guide that is free for everybody if you want to download that. And then we have everybody's contact information here from of our three experts on the call today as well. So again, I'll go over that more slowly before we leave today. Ladies, back to you.
Thanks, Jeff. So I did answer some of the Q&A while both ladies were going over. I left some open. A lot of questions about the CEUs. Some I was not as familiar with, so I left those open. The ones that I answered to my best of my ability. And then some of them I actually, after you were going on in your presentation, Kerstin, I was like, oh, wait, no, hold on. Let me add that to my answer. So just to clarify, a lot of times, just have your attorney look at your documents if you're unsure. Really, honestly, better safe than sorry. Money well spent. If you're unsure of something, what you can and cannot do with funding, with loans, because I'll be honest, I haven't seen a lot of community. I don't think I've seen any community that it was written in their docs that there needed to be a membership vote for a loan. That was the first. After you'd said that, Kerstin, I assumed that that's something the board could just determine and vote on. There is no membership vote. And then she said, well, if it's in your docs, and I was like, oh, wait. So personally, I haven't run into a community that I personally have managed myself that had that in their docs, but doesn't mean that's not out there. So I did go back and fix that answer. So again, a lot of these are about CEUs, so you ladies can read. I didn't feel comfortable with answering a lot of them because I wasn't completely sure. So if you want to go over, do you want me to read them or you can see them, Kerstin and Mary?
Let me see here. Yeah, and as a practical point, if you don't review your governing documents and confirm whether or not membership approval is required, and you go through this loan process and you're almost at the end, and then here comes your attorney that needs to now do this legal opinion, and the attorney discovers on the back end that you need membership approval, that's just going to delay the whole loan process, because then you have to go back and get that membership meeting. So get your ducks in a row, and certainly your attorney involved at the beginning of this.
Yeah, that's great insight, Kerstin, because a lot of times we have it where they tell us we don't need to do certain things, and that's why we request a copy of the bylaws, the amendments, and articles of incorporation, because we sometimes end up telling them what they need to do because no one on the board has taken the time to do that. And so then we have to push back and say, let's take 5 minutes, talk with your attorney, talk with your board, and let's move forward with the right actions in place, because the last thing we want to do as a bank is say you have an approval for a loan and then we have to take that back because certain things weren't followed. So we want to be as proactive as possible, but we can't do anything that isn't allowed or documented in your basically operating arrangement.
Right.
I don't have actual viewing of the Q&A, so I'm sorry, Courtney, I don't see any questions. So I don't know if you two can, but if there's something lending specific, I'm happy to answer, but I've just been playing with my screen and nothing else pops up, so sorry.
It should be a toolbar at the bottom, but most of these seem more, nothing lending specific to me, a lot more about the CEUs and what they can do with it, what they can't do, and how, like the one question I didn't feel comfortable, it was more in the beginning. A condo just approved a 25 budget. The CEUs draft was delivered after the budget approval. The draft contains the reserve plan starting in 2025. Can we delay factoring in the CEUs items until the 2026 budget? Do you see that one, Kirsten? It's the very first one.
Let's see, Connor just approved the budget. Yeah, so, right, so then it's if you had adopted the budget after December 31st of this year, that you would be sort of stuck, and then you would have to fully fund your CEUs. So if you've already adopted the budget for 2025, then the only thing is, it doesn't sound like you've obtained any membership approval, because you still require membership approval in order to waive any CEUs funding. So I would go back to your legal counsel, or certainly, we can further assist with that. I need a little bit more detailed facts about, how this vote transpired to further guide you on whether or not you're okay for 2025. But you do still need a membership vote to officially waive or partially fund CEUs if you don't want to fully fund for 2025.
So I'm sorry, this same person actually wrote that later on in your webinar, during your presentation, Kirsten. He wrote, so we can waive or partially reserve or partially fund the reserves for the CEUs for 25 scheduled by vote of the membership if done prior to December 31st, 2024. What percentage of the membership is required? Is it specified by statute, or do we follow our docs?
So it's a statute, it's the vote that's in the statute, which is a majority of the voting.
Okay.
Let me see. There was one question. There's a lending question here. Are there any, where is it? Are there any special considerations? Geez. Any special?
For the smaller HOAs?
Yeah, for the smaller HOA.
Yeah, so the question is, sounds like it might be for Mary. Are there any special considerations for smaller HOAs, 10 to 15 units, when seeking loans for capital projects?
Not necessarily. Again, it's going to depend on the size and scope of that project, and how much debt that is per unit. I think a lot of times we want to understand that. As Courtney even said before, the last thing we want to see is suddenly, your assessments are double or tripling. So we really want to understand that repayment source and how strong it is. Again, you might have some projects that, the residents can make those types of payments without any issues. And there's other projects where if you raise it more than $50, you're going to hear from a lot of people that aren't happy. So I think it's part of that dialogue that you're going to have with the bankers, so that they understand your uniqueness of your property and your project that you're contemplating.
Okay. And again, we're trying to look for questions that are not too specific. We don't have your documents in front of us. We don't know your associations. Here's one that's relatively general, and this will be the last one because we're past the time here. And then I'll go over the evaluation one more time. This one is pretty general. This could be either for Kerstin or for Mary. Have you seen where special assessments and regular assessments are combined onto one maintenance payment coupon if they're being paid simultaneously on a monthly basis? Is that something that's normal? Can that be done? Notwithstanding what a specific association says?
So typically we see them kept separate. They can go out at the same time, but again, we're always trying to identify what was this payment for and taking it back. And as looking at your financials, your auditors, your CPA, they like to see that direct line match to match. So we typically like that as well. So I would recommend, if you're doing it, keep them separate, but you can send them out at the same time and have them do it at the same time. That's not an issue.
It's also a lens for clearer record keeping, as you alluded to. You want to be absolutely clear, transparent, easy.
Another question here on interest. If you borrow for a source project, is the interest expense an operating expense, or is the source expense as part of the project? So if you're going to borrow for a project, right, there's going to be interest. So you got to make sure that when you adopt the special assessment to pay back those funds, that you incorporate the interest, right? So you're not just adopting a special assessment for the principal balance of the loan. You have to factor in all the interest on that loan. And then, speak with legal counsel. You might give owners the option that if you pay off their portion of the loan, then they might not accrue interest. But if you pay, within so many installments, then yes, you'll have to tack on interest. So again, a discussion you have to have with your legal counsel when you're preparing your motion to adopt that special assessment.
Okay. And Michael, you are not old. The Brady Bunch is available on streaming for everybody to see of all ages. It has nothing to do with how old we are. In the streaming world, everything is accessible like that. So, and Kerstin, looking like Jan Brady's not a bad thing at all. It is not a bad thing. So, any other questions before we explain the evaluation one more time?
I think I'm good.
Okay. So before we head out, I would like each one of you, we'll start with, we'll go with, speaking of Brady Bunch, this Zoom thing makes it look like it's the beginning of the Brady Bunch with the 4 squares. So I know, and here's a story of a manager named Courtney. Please tell us, everybody, how to reach you and GRS management. And folks, if you're happy with your management company, great, do nothing. If you're shopping, the folks at GRS are more than willing. They're wonderful. We all work well together, and they're very transparent. Courtney, how can people get in touch with you?
Hi, thank you so much, Jeff. So you can get in touch with me by email. That's always the best way. My email is C Buchan. Said my own email wrong. C as in Courtney is what I meant, and then my last name Buchanan. That's spelled B as in boy, UCHAN at grsmgt.com. You can also visit our website, grsmgt.com. There's many fields on our website. There's previously recorded webinars like today's. There's future webinars, and then there is an area to request a proposal if you would like one, and someone will reach out from our sales department. And then you can even call me. Again, I prefer email, but you may call me, and this is also a number that you can even text. My phone number, my work phone number is 561-941-4220.
Thanks, Courtney. And Tim in the chat area just mentioned, put the contact info in the chat. Well, when you fill out the evaluation, the submission screen will have everybody's contact information on it that you can print, save, download, the whole 9 yards. And I want to say the same thing for Bank of America. Wonderful experiences I always have with Bank of America. If you're shopping around, remember, when you're in the association world, it's never good to keep everything in one place. It's good to spread it out and about. So if you're shopping around, these 2 ladies can certainly help you. How can you get in touch with you guys if you're looking for some assistance?
Thanks, Jeff. So email is definitely the best for us. So my email is Mary, MARY, .CONE @BOFA.com. And really any market that you're in, even if it's not a market that I sit in, I've got connections and contacts throughout the state of Florida, and we can find the right relationship manager that can help you and answer your questions. So happy to help any way we can.
Wonderful. And Courtney and Mary and Karen, thank you for inviting us to participate today. And lastly, Kerstin, before I go over the evaluation one more time, any parting words from you, my friend?
Sure. Yes, you can email me, and I think my email is going to be on the slides that you'll be able to get after the webinar ends. And yes, you can call me. Believe it or not, I do pick up my phone. You'd be surprised how many clients have turned over from other association attorneys and have said, we call our attorney, and 3 months later, we still can't get in touch with our attorney. Yes, right. I pick up the phone. So you can call me or you can email me.
Wonderful. And I can attest to that. I became aware of K. Bender Rembaum 20-something years ago when I was on site, and I can attest to that. Customer service is paramount with this firm, and I'm happy to be a part of them right now. So ladies, thanks everybody.